In our previous two lectures, we have already discussed about Water Prevention and Control of Pollution Act 1974 and the Air Prevention and Control of Pollution Act 1981. So, in this lecture, we would like to discuss about prevention and control of noise pollution. So now we would like to discuss the very introduction relating to prevention and control of noise pollution. So the central government in 2000 made the noise pollution central regulations and control rules to maintain air quality standards in respect of noise. So Rule 5 and Rule 5A and Rule 8 are important in connection to prevention and control of noise pollution. Rule 5 of the rules provide restrictions on those of use of loudspeakers, public address system, and sound producing instruments. And Rule 5A provides restrictions on the use of horns, sound emitting construction equipments, and bursting of firecrackers, while Rule 8 states the power to prohibit continuance of music, sound, or noise. Under this rule, it provided the ambient of air quality standards in respect of noise as following. So, in particularly regarding industrial areas, commercial areas, residential areas, and silence zones, the air quality standard determined under the rules as such. In industrial areas, the daytime limit is 75 decibel and night time is 70 decibel. For commercial area, it would be around the daytime limit is 65 decibel and night time is 55 decibel. In respect to residential area, it is 55 decibel in night, and in daytime it is 45 decibel, respectively for daytime and night time. For silence zone, it is 50 decibel at night and 40 decibel at daytime. So, as noise pollution is a nuisance, so the very punishment we found as under this Indian Penal Code. So, Section 290 of Penal Code provides punishment for nuisance as an offense which is falling under public nuisance. And Section 133 of the Criminal Procedure Code provides the magistrate powers to make conditional order requiring the person causing such nuisance to remove such nuisance. The law of torts also considers it as an actionable wrong to constitute legal liability causing substantial damage to the comfort and convenience of the plaintiff. While Section 30 of the Police Act 1861 lays down that the Superintendent of Police is authorized to regulate the extent to which music, may be used in streets on the occasion of festivals and ceremonies. The Factories Act of 1948 under third schedule contains the disease of hearing loss caused by noise, while Section 11 of the Factories Act 1948 also could be invoked to control noise pollution. The Air Prevention and Control of Pollution Act 1981 authorized the Central Pollution Control Board to include noise in its plan and program and to lay down noise standards. The Motor Vehicles Act 1988 with amendments in 2019 under Rules 119 and 120 deal with reduction of noise, especially regarding horns and silence of certain vehicles like agricultural tractors by fitting new devices for such purposes. The Environment Protection Act 1986 under Section 6 empowers the central government to make rules to regulate the standards of quality of air. So, also we found certain other important efforts made in the field of judiciary, which we would like to discuss here the judicial efforts and mechanism to prevent and control noise pollution. So, in that sense, as we found the very important decision, and in that connection, we would like to discuss the provisions under Constitution regarding noise pollutions in relation to Article 19, Article 21, and Article 25 of the Constitution with the important leading case. So, in that connection, we would like to discuss the first one that was relating to the Allahabad High Court, where it was held that prior permission of the executive magistrate to use loudspeaker does not violating of Article 19 of the fundamental rights provided under Part 3 of the Constitution of India. In the same way, the Calcutta High Court in Masood Alam versus Commissioner of Police in 1956 held that restrictions on the use of loudspeakers does not violate of the religious freedom guaranteed under Article 25 of the Constitution, as the restriction in length as public order, public health, and public comfort is the main consideration in invoking the rules of noise pollution. So, also the Kerala High Court in PA Jadhav versus the Superintendent of Police in 1993 in similar sentiment held that the right to speech implies right to silence. So the Calcutta High Court also held that Article 19 freedom to speech implies also freedom not to listen and to remain silent in case important case relating to whom Virangana Religious Society versus the State in 1996. Again, the same High Court held in Mufti Said versus the State of West Bengal that use of loudspeaker is not an integral part of right to religion. Also, the Supreme Court in the case of Church of India in Court versus KKR Majestic Colony Association in 2000 held that no religion prescribes that prayer should be avoided by disturbing the peace of others by using amplifiers or by beating drums. Article 19, Clause 1, Subclause G, which deals with freedom to practice and profess, said, and occupation is also linked with the problem of noise pollution. So, in the very leading case, Burrajar, where Works Association versus Commissioner of Police Calcutta in 1998, the court declined to provide any relief to the petitioners by expressing that Environment Protection Act 1986 stipulated that noise emanated above 65 decibel sound beyond the ambient limit takes away community's safety, health, and peace. So, in another important leading case, and that is rural litigation, Kendra versus State of Uttar Pradesh in 1988, the Supreme Court defined the scope of right to live in a noise-free environment. And in another important leading case, that is Vijayanand Patra versus District Magistrate Cuttack in 2000, while disposing a public interest litigation, held that noise can well be regarded as a pollutant because it contaminates environment, causes nuisance and affects the health of a person and would therefore offend Article 21 if it exceeds a reasonable limit. And in 2001, in the Free Legal Aid Cell versus the Union Territory of the National Capital Territory case in 2001 against the government of Delhi, it was held a similar view that display and use of firecrackers during festivals and marriages causing physical and mental hazard of adults and children are violative of Article 21. So Justice R.C. Lahoti of the Supreme Court in 2005 expressed that right to live in freedom from noise pollution is a fundamental right protected under Article 21 of the Constitution of India. So also the Supreme Court on re-implementation of laws for restricting the use of loudspeakers held that noise pollution creates irritations and disturbance to people, which is a continuing wrong all over the country to ensure strict compliance of the conditions or steps which should be done in the larger interest of the residents of the concerned area. And in another important leading case, and that is Ram Neela Maidan case in 2012, the Supreme Court held that right to privacy and collective life, collective responsibility on the one hand, and individuals' rights and responsibilities on the other hand. So far, silence zone, as we found that it was held by the Supreme Court that the individual's rights and responsibilities must be concurrent and coexist with collective life and collective responsibility. So, in that connection, we found, which we have already discussed regarding the provisions of criminal laws in connection to noise pollution as Section 290 of Indian Penal Code and Section 133 of the Criminal Procedure Code and the provisions of law of torts. The Police Act 1861 provides regarding noise pollution under Section 30 and Factories Act 1948 under Section 11 and the Air Prevention and Control of Pollution Act 1981, the Motor Vehicles Act 1988 and those rules framed in 2009, in particularly rules 119 and 120, and finally the Environment Protection Act 1986 under Section 6. So, again we would like to discuss such provisions. So, noise pollution is a nuisance as we found it under the Indian Penal Code under Section 290, which provides punishments as nuisance under the Act is considered as public nuisance. So as under Section 133 of the Criminal Procedure Code, it refers the powers of magistrate to make conditional orders requiring the person causing such nuisance to remove such nuisance. Even under law of tort, we found that it is an actionable wrong as it caused damage to the comfort and convenience of the plaintiff. Even under Police Act under Section 30, we found that a superintendent of police is authorized to regulate the extent to which music may be used in streets on the occasion of festivals and ceremonies. Also under Factories Act 1948 under Section 11 of the Act, we also found that there could be invocation to control noise pollution created by the factories as falling under Factories Act of 1948. So also we found under the Air Prevention and Control of Pollution Act 1981, which authorizes the Central Pollution Control Board to include noise in its plan and program and to lay down specific standards regarding noise emission. Also, the Motor Vehicle Act 1988, which was amended in 2019, and those rules, particularly rules 119 and 120, which provides regarding reduction of noise, especially regarding horns and silence of certain vehicles, like agricultural tractors, by feeding new devices for such purposes. And finally, the Environment Protection Act 1986 under Section 6 empowers the central government to make rules to regulate the standards of quality of air. So, in this lecture, almost we have touched every piece of legislation starting from Indian Penal Code, Criminal Procedure Code, the Law of Torts, the Police Act 1861, the Factories Act 1948, the Air Prevention and Control of Pollution Act 1981, the Motor Vehicles Act 1988, and the rules framed under the 2019 amendment also. Finally, we have discussed the very important provision relating to Section 6 of the Environment Protection Act 1986. So, almost we have touched those important rules of 2000 relating to prevention and control of noise pollution, in particularly Rule 5, Rule 5A, Rule 8. And also we have discussed the various standards laid down regarding air quality for specified areas such as industrial areas, where in the daytime and night time standard decibels. We have discussed also regarding the air quality standards relating to commercial areas, residential areas, and silence zone in respect to daytime and nighttime limitations of decibels in regards to emission of noise. In that connection, also we have discussed the constitutional provisions in relating to noise pollution, in particularly Article 19 and Article 21, so also Article 25. In connection to that, we have discussed some important rulings of different high courts, such as the decision laid down in those important leading cases, such as the Masud Alam versus Commissioner of Police in 1956 by the Calcutta High Court, and also P.A. Jacob versus Superintendent of Police also. Om Brahmana Religious Society versus the State in 1996, and also the Church of India in God versus KKR Majestic Colony Association, decided in 2000, and also Bar Bazaar Fair Works Association versus Commissioner of Police Calcutta, and also the most important leading case decided by the apex court, Honorable Supreme Court, and that was Rural Litigation Kendra versus State of Uttar Pradesh in 1988, and also another important leading case, that is the Free Legal Aid versus Union Territory of the National Capital Territory, Government of New Delhi in 2001. So another important leading case, and that is Ram Lilla Maidan case in 2012 relating to noise pollution. So in this lecture we have finished or discussion on noise pollution.